Hi, my name is Alex Dolphin, and welcome to Ante. This is a brief show where we digest cases and we talk about the facts of the case, the ruling, the holding, and then future implications of that case law. So that would be the ex-ante implications and the reasoning for the show. So welcome to it. I don't publish this to float my ego. It's mostly just to prepare myself for law school. I wanted to work on talking in front of a camera and presenting legal issues to an audience. So that's the reason for the show. If you get something out of this, I hope you enjoy it. So today I want to talk about the case of Kelo versus the City of New London. Kelo is the plaintiff in this case, and the City of New London is a defendant. This is a seminal property rights case that was argued before the Supreme Court in the year of 2005. Ultimately, the ruling came down in favor of the City of New London, but let's go ahead and give you a little bit more of the facts behind the case. So the City of New London had an economic development agency. What that is it's a small form of government underneath the city and usually given authority by the state legislature. This government has the ability to try and fix blighted areas, as well as just promote the economic welfare of the city. It sounds like a good thing to most people, but let's just kind of talk about some of the consequences that come out of that. So the City of New London claimed that it had eminent domain power given to it from the state legislature to take the property of Kelo, who's a petitioner, and 9 others in this case. They had property that was desired by the Economic Development Agency because they wanted to put a gigantic lab for Pfizer there, so a big corporation. Their argument was that if they brought Pfizer into the city, that a lot more jobs would come into the city. It would be an increase in both jobs and tax revenue in the future. So that was their reason for the taking. Kelo argued that this was unconstitutional, and to understand why Kelo argued that it was unconstitutional, we need to understand the takings clause a little bit more. So let's dive into that. It's in the Fifth Amendment. It reads that private property shall not be taken for public use without just compensation. And when we say taken, we mean taken by the government. Kelo is arguing in this case that the taking was not for a public use, rather it was for a private use. This is because the land that was taken was meant to be given or developed upon for Pfizer. Pfizer is a massive pharmaceutical corporation, and the petitioners, Kelo, argued that this wasn't a public use for the taking. So the taking, they argued, was unconstitutional because of this. Whereas the City of New London argued that this taking was constitutional because it was a public use. The courts interpreted public use in different ways. Sometimes it's interpreted it to mean a public purpose. And so they kind of took that definition of public use and ran with it and argued that the public purpose for taking this property was to increase the tax revenue by bringing in a large corporation like Pfizer, along with increased jobs. There was reports that there would be 1,000 jobs added to the community because of this. So that was the argument on either side. It kind of hinged upon the takings clause in the Fifth Amendment, and more specifically, just the definition of public use. Ultimately, like we discussed earlier, Kelo lost and the City of New London won. It was a split decision, 5-4 in the Supreme Court, where they held that the City of New London's taking, or more specifically the Economic Development Agency's taking of the property, was constitutional because it did constitute a public use. The taking of the land was meant to, in turn, increase the economic prosperity of the community, create more jobs, and the court saw that as a fit taking. It is also worth noting that they just stated that they weren't going to opine upon, whether that was the best thing that could have been done with the land, because they just felt that that was left up to the legislature and it was best for them to have that authority vested in their hands and not basically what the court needed to get into. So obviously Kelo was dissatisfied, so was Justice O'Connor, as was Justice Scalia and others, and a lot of conservative voices, mainly because this taking of property in a lot of people's eyes wasn't constitutional. The public use in most of our minds is perhaps a road, railway, maybe even a park, right? But we don't think of public use as the development of that land for a private agency. So let's talk about the ex ante implications of this case. The first would be that we've kind of created property czars in these economic development agencies. We've given them broad, sweeping authority to take anyone's property if they can argue that there's going to be an economic good. And that's the signal that the Supreme Court sent to all the cities, towns, counties with economic development agencies. So that's a bit concerning if you hold private property and if you're worried about it being taken. I mean, yes, you'll get justly compensated, but you might have a sentimental value associated with your property. Maybe it's the house that your grandma lived in or the house that you grew up in. Second is, let's apply this case and let's just kind of go on a stretch and let's apply it to intellectual property. Intellectual property, some have argued it's kind of muddy waters whether the Fifth Amendment applies to it, but let's just say that it does in this case, and in turn so does the court's ruling in this. What if a city were to create an economic development agency that wasn't really tasked with, fixing blighted property or bringing more corporations to the state? Rather, it was just tasked with the purpose of increasing economic prosperity in the state. Well, if the purpose of an economic development agency is to promote the economic well-being of the community, maybe what they want to do is get a company's intellectual property and share that with other companies so that the price could be brought down, right? So think about cell phones, for instance. Let's think about Apple. Apple obviously has a lot of intellectual property associated with the iPhone, with iOS, and all of that good stuff. So let's imagine that an economic development agency is tasked with the purpose of creating more economic well-being, and they see that Samsung can create a phone, and at least Samsung executives have said, if we just had Apple software and there's trade secrets, well, we would be able to create a smartphone for $50 and anyone on the street could have it. Even homeless people could have it and call and be safe, and everything's going to be better because we're all going to have these awesome phones for $50. Samsung says they can still make $30 a phone and everyone's happy, right? Well, under this case, I think it's kind of hard to argue that economic development agency wouldn't have the right to take the intellectual property of Apple and then distribute it to others. There's definitely, it can be argued, an economic good on the other side of that redistribution of property, as in all citizens will have cheaper iPhones. So that's a bit concerning. I think that's one of the ex ante implications, and those a stretch, right? And an economic development agency that we're talking about doesn't truly exist, but it could one day. In this case, might very well be cited upon to try and hearken back to that precedent and say that, hey, maybe we should give these trade secrets to other corporations in the name of economic well-being. So those are two ex ante implications I wanted to talk about, intellectual property and then just basically creating property czars, for lack of a better term. Thanks so much for watching. I hope you enjoyed the show and I hope you got something out of it. Have a nice day. Thanks.